All right, a very good afternoon to you and welcome to the program. It is Good Afternoon Ghana, and we'll be focusing definitely on the country Ghana. Today, we are turning our attention to data. There's been the controversy about, get your Ghana card, register your SIM number. That is not the part that we're dealing with really this afternoon. We're dealing with Data Protection Act, or maybe Data Protection Law. We'll have some explanation to it. There's been, 2019, there's been 2021. We'll have the explanation to all that. But really, is it about the protection of your privacy? Is it about the protection of you processing your data and keeping it safe? What exactly is the data protection that we've been talking about here in the country? And a couple of times, our leaders have told us that you need to protect your data. There's cyber fraud, and people are really doing things with your data. Does that mean that those who are also in office and have been put in charge of the system, are they bound by the law to also protect your data by not going into your data? Because sometimes you hear things around, you know what I'm saying? So, we'll get into that and have a discussion. We would have Patricia Adusei Poku, who will join us. She's the Executive Director for Data Protection. She's going to join us pretty shortly after this break. And when we come back, all the questions that you have about data protection, send them to me. I'll respond, or she will definitely. She will respond because she'll be with me on the platform. This is Good Afternoon Ghana. I am Ani Ifwa Ampof. Will be back shortly. Welcome back into the studio. It's Good Afternoon Ghana. Earlier on told you that we're doing data protection today. So at a glance, you can think of lawfulness or the legal nature of the act. We can think of processing of data. We can think of the storage. We can think of the fairness. We can think of so many things. RTI, it's a little broad, I think, in my opinion. But Patricia Adusei Poku will help us understand, Executive Director for Data Protection Commission, and she's in the studio as my guest today. You're welcome. Good afternoon to you.
Thank you.
Thank you so much for coming on the program.
Yes,
so, first, let me just find out from you if, at a glance, you think that Ghanaians understand data protection.
I won't put it so broadly. So the corporate world now are waking up to the fact that they have obligations under the Act. However, the community, the people, the members of the public are still struggling with the definition and how it applies to them. Yeah. I say the corporate world, but there are so many institutions that also are not fully informed about their obligations. So it's an uphill climb for us as we educate the public and the institutions that hold data.
Okay, in that case, I will want you to tell me a little bit about your office as the Executive Director, Data Protection Commission. Tell us a bit about it, and then we can go into.
Okay, so the Data Protection Commission is established by the Act 843, which is the Data Protection Law 2012. That establishes the office, the Data Protection Office, as the statutory institution that is responsible for protecting the rights of individuals under the Data Protection Law, which is their privacy and their personal data. We stand in the stead of the people of Ghana to scrutinize what institutions do with the information they collect, to ensure that they abide by the set principles that is set out in the law, and also to ensure that they are meeting their accountability obligations to the public, which is meeting the reasonable expectation of the members of the public, you and I, who give our information to institutions, both public institutions and the private sector institutions that has that have a purpose to actually create a database of information. And when I say this is any structured filing of personal data, anyone who collects information with a purpose of delivering a service or creating some sort of product to provide to the public or for profit making or even for non-profits, all fall within the scope of the Data Protection Act. So long as you have like a member of staff whose data you have collected to do some business with, you have one customer or more, you have to comply with the requirements of the data protection law.
And you've been in this office for how long? I mean, you in person as
So the office was initially established from between 2015 to 2017, and I took office in 2017.
Oh, okay. So there was someone there before you took office?
Yes. So the previous government had commenced the setup of the office before this new government took office, and I was appointed in 2017 to establish the office and to ensure that the rights of individuals are protected.
Okay, so let's deal with the data. What's this data that we're talking about that people collect?
Okay, so that's a good question. Data is any collection of information that enables a purpose to be achieved. So it can be business generic data. When you want to start a business, the business needs a name, the business has plans, maps of what they are going to do, the purposes, the business case. That is generic information. But the part of business information that is within the context of this law is the information that concerns individuals. So any data that can uniquely identify an individual falls within the scope of the data protection law. So employee data, customer data, any individual's data that you come across in the course of delivering a service or a business, your suppliers, partners, international people that you collaborate with. And in the context of data protection, it's not just about Ghanaian citizens, it's about any information that identifies an individual, and that covers tourists, immigrants, foreigners, people passing through Ghana, people here to do projects, and Ghanaian citizens. So it's about people in Ghana at any point in time, not just citizens.
How do you get access to such data?
So the Commission do not actually access the data directly, but we hold institutions accountable for the information that they use in their businesses. Okay. We don't actually see the data. We show them what principles by which they should do their business. We check what legitimate grounds they have. Some businesses and organizations have a law backing what they do, such as banks, such as some schools, some education, some hospitals. They have the laws. They have government ministries that create the agencies to collect information. Or as private sector institutions, they have a purpose by which they collect the information. Or as NGOs, they have a purpose to serve one service or the other to the people in Ghana. So for whatever purpose that entity exists, that purpose determines what data they collect. Whenever that decision is made to collect data, the person who made the decision or the law that mandates that setup of the organization to create the database it determines who the data controller is. And any entity that exists, especially those who are registered with the Registrar General or are tax-paying entities, they are known as data controllers because they need data to be able to deliver the service or the purpose.
So let me bring in one of these controversial issues that we're facing with one that has to do with Aisha Wan. We don't have data on her, or we have data and the data says that she is not permitted to be doing what she's doing. Persons like her, how does the Commission come in? So
as an individual, Aisha is a person in Ghana at the moment. So she's entitled to service from the Data Protection Commission in terms of protecting her personal data from being widely accessed or unauthorized sharing or wrongful sharing of her information. That right is the right to be protected against harm or distress. So as...
Who has this right?
Aisha, the individual that you're citing as a case study, that any individual, you or I, whatever the situation that caused your data to be collected by whatever institution, gives you rights under the Act. So she or any individual has rights under our Act. The right to demand for her privacy to be respected. The
So
right.
in this case, we've already gotten copies of her data,
Yes.
passports,
Yes.
documents signed, and things like that. She has a right to request for her privacy,
Yes. So.
and under that act, she can sue.
Yes, so if her data is being accessed wrongfully or being shared to the public arena wrongfully, then she will have to, she can assert herself, please, let me put it like that. She can assert herself under the law, especially if the information that has put out there can lead to harm and distress for her, then she has a right to assert herself under the law. So wherever she gave that information to originally, have a duty to protect who has access to the data or can share it with authorization, either on a legal basis or with her consent. So supposing, I don't know about what you're saying, but you're saying her passport details. Supposing her passport details is on social media, then if it was released
It
by...
is on social media. We're not even supposing.
Okay,
Actually, it is.
I don't know about that. But
is.
if it is, then whoever put it there has wrongfully shared personal data that should be kept private to her.
Personal data that we regard illegal.
Well, passport information is not illegal information. Everyone is entitled to a passport. So if she has a passport, it's her personal information. And to put it out there in the public arena has to be achieving a certain purpose. If it's for legitimate reasons, then we don't have an issue with it. But if it has just been put there because she's on the news, then it's not fair to her.
So, I mentioned a few points when it comes to the data protection, and transparency is one that was captured under that. And considering, and I'm not picking on Aisha one, I'm just Aisha one in quotes. It's just a scenario that I'm trying to put across, just in case there's anybody in this particular situation. So transparency is one of the key words in the data protection.
Yes.
And because of the type of business Aisha One has gotten herself entangled in, there seemed to be an attempt to be transparent with the people.
Okay, so without dwelling too much on that specific case study, I'll explain what we mean by transparency. So transparency is that the institutions that collect our information should give us, the data subjects, we are the data subjects, those of us whose data is collected by any institution that has information concerning us. Could be our school, our doctors, our employers, or whoever has collected information about us, we become their data subjects. They have a duty under our law to protect the information that they have collected for the purpose that they originally collected the information for. So in the scenario that you're just explaining, the fact that a person is in some sort of trouble or situation and her details have been shared as headlines doesn't allow that institution to then put whatever they have on her in the public arena. That is breaching her rights to privacy. So your passport, if I have your passport because I've been traveling with you, it doesn't mean I should copy it and put it on social media, because your passport contains critical information about you, your name, your age, probably where you even got the passport from, how long it's valid for. And these bits of information is personal to you. So unless there's a law backing the sharing and distribution of that information, it's supposed to be continuously protected or safeguarded by the institution that originally collected it.
So how about criminals who are sometimes arrested by the police and the type of information police shares about them? His name is so and so, his age, where he works, sometimes unemployed, youth, students, and stuff like that.
So sometimes we were just discussing this at the RTI meeting this morning, that due to public interest, certain information that can be personal data or private to an individual has to be shared to protect the general population. So sometimes you need to do this public interest test to weigh the rights of the individual, their privacy, against the general well-being of the public. And one will sometimes outweigh the other. Supposing in the scenario you've given me, if it's, say, a pedophile or an ex-convict that is likely to harm members of the community or children, then the police, together with court and the Data Protection Commission, may analyze that situation and decide that the information must be put out to protect the general public or the masses rather than protecting that individual. It's a rare decision that is made. But in general, the person, that individual, even if they are a criminal of some sort, will still be protected as a fundamental human right, unless it's definitely a public interest and protects more people than that individual to release the information.
Then same principle must be applied to Ashawan.
She can seek that right. She has the right to assert themselves. The fact that someone is in a situation does not override.
I'm just considering the fact that it's the same thing that can be applied to her, because what she does, we're told it's also criminal. And in the, general well-being of the public, of course, Galamsey activities is harming the public than doing them good. So if we're looking at the larger positivity, it is the public first we're looking
Usually, in the situation that you are discussing, is the public that has put Asha's information out to determine whether information.
But they got it from the right institutions.
No, but if a person's information is supposed to be put out in the public arena, it needs a court decision. Usually, the court and the Data Protection Commission would need to do this public interest test to determine what should be put out there. How much of her personal data is relevant to the situation and to the public to be put out there. I don't think sharing her passport details saves us from Galamsey in the context that you're discussing it. So
in the long run.
So the court, together with the commission and probably the representative of that individual, would have had to discuss how much of that information to put out there for the benefit of the general public and to save a certain situation rather than the individual. I don't think that test has already been done. So I'm not answering for her, but it is likely that she can assert herself under the law.
Means a lawyer can take that action.
Yes.
Do our leaders know this?
They should know.
Do they know?
I'm not sure how many people know, but that's why we are here educating ourselves about the law. Data protection law has a lot of principles. It empowers individuals a lot. People have the right to stop the processing of certain information. They have the right to object, right to claim compensation, right to ask for erasure and deletion of certain information that is out there about them, and the right to sue if their rights are not respected. So if Asha actually knows exactly how the data went out, then she could complain to that institution or to the commission for this to be investigated.
This is...
So the institution that collected the information that is out there, they have a duty under the Act to safeguard the information and to use it for the purpose for which they originally collected the information. So it depends on how the information got into the public arena.
So how does the fairness in data protection also represent itself? How does it play
So
out?
fairness is that when you go to any institution to give information out to that institution, say you go to a hospital, especially the public institutions, when you go there, they have a right to collect information about you. If you come to any government office like Ministry of Education, Ministry of Health, or they have several agencies that provide a service to the public. In the provision of the service, they collect a lot of information about you. They collect it because they are empowered by a law, an act of parliament that allows them to collect your information to provide a service to you. Now, to be fair to you, they must explain what they are doing with that information. Even though they have the law backing them to collect your information, you, the individual, have one of your rights is the right to be informed. So under the right to be informed, they need to be transparent about why they are collecting the detail from you. Why so much information? Why your biometrics? Why your passport details? Why Ghana card? And then show you what it is going to be used for, how long they are keeping it, how they are storing it, who will have access to it, under what circumstances the data will be released to a third party outside the context of the purpose that they have just explained to you. So this is what we call the privacy statement. You should be given a privacy statement that explains everything that would happen to the data from the point of collection to the end of its life cycle.
Wow.
That is fairness and transparency.
That's interesting.
Yes.
Do our companies have the responsibility of doing this
Yes.
when they collect our data?
Every
Must
point
they
of
give us
collection.
Agreements?
Yes.
The privacy or agreement?
Privacy statement.
Statement.
And now these privacy statements are usually in many institutions on their website. When you go to the About Us, they usually have a privacy statement listed there that tells you what information they collect in the routine of their business, who has access to it, how long they are keeping it, and after they finish, if it's say a project with an end, for example, they should be able to tell you what happens to the data after the purpose has been reached, and then how the data will be purged or disposed of. You have a right as an individual to be informed about all of this in order for you to give your consent to the collection and sharing of the data. And if you're not happy with the explanation, you can have your right not to give your information institution. That is what transparency and sharing is about. And if you get all of that, then your right to be informed is being respected. It is the basis on which you give consent to your information being collected, especially with those institutions that do not have a legal basis, a law backing them. In the private sector, for example, they must tell you all this information so you can give them your consent to use your information.
This explanation you're giving, is it something that robs off right to information?
Yes, so the Right to Information Act works hand in hand with the data protection law. Everything that is not personal to you, that doesn't uniquely identify you, should be able to be disclosed. But the Right to Information Act just applies to the public sector institutions, not the private sector. Whereas data protection is every entity, private sector, NGOs, whoever has set up to collect data, they must respect your rights. The public service institutions under the RTI need to disclose to members of the public every information that is not personal on request. That is the right. It gives you the right to access information for your work or for whatever purpose for which you need that information.
Let me ask this. Maybe you may consider it a little controversial.
Yeah.
We have officials that sometimes when we put in office, people demand that we should know their health status because you're coming to serve in their capacity as a minister, as a president, as an MP, whatever. Because sometimes along the line in their service provision, you find a whole, plethora of
cost to the public.
Yes, it becomes a burden, and then people begin to demand. Well, they have the right to demand, but according to this data protection, how should it play out?
That's a very intelligent question. And if these principles were applied at the point of collecting information, perhaps the public would save a lot of money. But specifically, if a person is a public sector employee or a public servant, as we are described, then their data is not wholly personal because the public is your employer. And if you're employing somebody, you need to know a whole lot of information about them. So, for example, our members of parliament or our government appointees or certain people in the public sector serving the public, parts of their details should and can be made available to the public. My name is not personal to you. My job title is known to you. And my job location is known to you. Why? Because I serve the public. So public servants' details, sometimes their location, and even to some extent, some salary information can be made public because they are public servants. However, aspects of their person, their self, maybe their health information, may be withheld to protect them from harm and distress. Where you are taking a certain specific position where the public deem it necessary to release more of your personal data, then the public interest test, like I said before, how the public interest outweighs your personal privacy will be tested again for the decision to be made as to whether the public should get to know more about you than general. So as and when the public interest becomes high, or when the demand requests that a lot more of the individual should be shared, then the decision will be made to put that out there, especially if you're a public servant.
So if, for example, you use some state funds and you explain it to be for health purposes, then they would have the right to investigate if indeed you are.
If the public agitate enough, then it will be their right to know. But it will be the test to be done by the relevant quarters to decide whether that information is demanded by the public and should be made public. But it's not a case of a journalist just finding it from the back door and putting it out there without the test being done. That way you may breach that person's privacy rights. And your privacy rights is just like your fundamental human rights, and so should be respected to the extent where it should be safeguarded until the test is done to show that the public has a right to know. So in some circumstances, what I'm trying to say here is that in some circumstances, personal data would be put out to the public because of the interest that is higher than the rights of the individual.
Do these people still have rights when they die?
So that's another good question. So data protection covers living natural persons. So whilst you are alive, the law covers any information that uniquely identifies you. So any information that we put out there that can uniquely identify you is your personal data. And now personal data covers a whole lot of data sets than what it was before. In olden days, it was just your name, email, your telephone number. Email came in as advanced technology became usable. Then emails became identifiable, combined with your name, obviously, and maybe your IP address. But IP address as advanced technology enables the tracking of systems and people such that a device identifies you, your IP address is also becoming personal data. Now, a person's location has recently been added to the list of personal data because of the use of GPS devices. Right. Because the GPS device can spot you, put you at a particular location at a particular point in time that can uniquely identify you. And so now, GPS location is personal data.
So it means that Data Protection Act is now being situated within the digitalization process. Definitely. It closely aligns with the digitization of data. Your biometrics, your genetical information is all now newly added data protection, personal data scope of areas that can uniquely identify an individual and so counted as your personal information. Where previously, when the systems were more manual, it did not extend that far. But now it's very wide. So when I say locations, now the minutes of a meeting can be claimed as personal data, whereas previously when systems were more manual, it wasn't. Mm-hmm. So on the issue of the death, I was asking that because when a high-profile person dies, there's also that question that throws in there, and there's so much controversy that why is it that our president has died or former president has died and we don't know what killed him? And then people are asking, sometimes the family will write a letter and say, oh, we plead with you to give the family some privacy, do not discuss issues surrounding his death or what killed him and stuff like that. And sometimes where I find myself, I am torn between the two, to help the public understand what's going on and also help the other side of the party accept or protect them as they are requesting. So you don't know which is which. So
sometimes in the discussions around release of personal data, especially when a person has died, we also need to take into consideration that in releasing information about that person, you are also releasing information that uniquely identifies their living relatives, individuals, children, spouse. So again, if the person is a high-profile person that is of public interest, then the test must be run to see how much of that information can be put out. And sometimes the information eventually becomes public generic information, but the timing is delayed to protect the other individuals impacted by that situation.
So you have purpose limitation, data minimization.
Exactly.
Is that what you consider when you're...
So purpose limitation is where an institution tells you, a hospital, your doctor, you go to your doctor, and the doctor wants your name, your how much food you've eaten, what have you been doing, because all sorts of information about you for a specific purpose, and the purpose is to help you heal up, to give you medical attention. Now, that is the specific purpose for which they are collecting the information. Now, you don't want that tomorrow you leave there, you come to the office, and they are listing all the pregnant women this week, and your name is listed. You may not be ready to tell your colleagues that I went to the doctor to have my blood test done because I thought I was pregnant or I am pregnant. And because they want to have a discussion about all the pregnant women of 30 years or a certain category, and you fall within the scope of that category, your doctor has released the information. So the purpose specification is to say to the institutions that you use that information for the specific purpose for which the individual gave you the data, and not beyond it. Anything beyond it, they must consent for you to do it. So the law may back you as a doctor to collect enough information to do your work, but for the specific purpose for which you collected the information, and nothing beyond that. If you try to use it for something beyond that, it's called the repurposing of the data, and you must ask for further consent from the individual in order to repurpose the data. And the data minimization is of all the information that they have collected concerning you using this same hospital scenario. The doctor must do the data minimization by using just the minimum necessary to be able to achieve the purpose. You get some institutions that give you a form that will collect so much information that you begin to wonder, what has this got to do with why I have come to this office? They want so much information, and that kind of collection we call the just-in-case collection. So they might collect information just in case they need it tomorrow, but it's
Hold on,
it really
just in case, it's an official...
it's an official description.
It's an official
Yes.
title
Yes.
or name of
Yes.
that process.
So when institutions are collecting more than they need in order to serve you, they are doing the just-in-case collection. Collecting just in case they might need it for some other reason in future. Sometimes they do that on purpose for marketing reasons. We know of one, I won't name the institution, of a private sector institution that is demanding that you give them a whole lot of information about yourself before they sell you a home product, an item. So you go to the shop to buy stuff from that shop, and they are collecting a whole lot of information under the guise that is going to be used for your warranty when the item goes wrong. But there's no telling whether the item is ever going to break down or not break down. But they are collecting all sorts of information, your address, your age, your gender, just to be able to serve you or sell you a product. So that sort of collection is what we call the just-in-case collection.
I see. The when you mentioned the hospital, I was just thinking about someone who is sick.
Yes.
In a dire situation, and sometimes they try to collect the information because based on which they have to give the medication.
Yes.
And then after, maybe the doctor goes, "What's your age?" I pause a little and look at the doctor. What has my age got to do with it? And now I'm going to ask the doctor, give me the privacy statement.
So the privacy statement doesn't always have to be that piece of paper with all the explanation on. The doctor talks to you as they're serving you and explaining. A good doctor always tells you why, even why they're drawing blood, why they're collecting this information. And whenever you pause and you ask, why do I have to give you this information? They have a duty to explain to you why that information is also needed in the provision of the service to you. When they are doing that, they are being transparent to you, you are being informed, and you are consenting based on the information you have been given.
Can you consent orally?
It's done, especially in our African context.
Actually,
but the
especially in African context,
yes,
you
it is
shouldn't
done.
do oral consent.
But because of the specific challenges we have in the African regional ecosystem, it's not a Ghana thing, it's the whole region. Our language barriers, our access to internet, our access to connectivity or understanding of how to use online systems. Most companies will have like a checkbox for you to check to determine whether you're giving consent or not, some affirmative action. But in our ecosystem, we have people who have literacy problems, who do not understand the English as a first language, who cannot read and write. So you give them a document and they can't write or read it to express to give you that explicit consent that shows that they have understood something. And so in the African regional ecosystem, and coincidentally, Ghana has the presidency of Africa Data Protection Commissioners. So I represent Ghana as the president of the African Data Protection Commissioners, as their president. And we are constantly thinking about how we define consent for the Africa regional ecosystem, because we find that the definition of explicit consent, which means that you have an unambiguous understanding of the purpose that has been explained to you before you take an affirmative action, which could be a signature on a form or some biometrics given, or some online checkbox that says that I agreed to do something. When we look at the demographics of Africa and the ecosystem that we are in, a majority of our people don't have these opportunities. In the rural communities, how are they going to do that affirmative action? And so we are looking at this oral explanation and how we can add it to the definition of our African context. And this is some of the challenges we have with the global ecosystem and the definitions of some of the terms in the data protection community. So we are looking at the African speak. And personally, I believe that if someone can affirm to the commission when they come to us to say that I got the full explanation, I understood it, and I gave my consent, that we will work with that, rather than say, where's the form you signed, or which website did you go to check it, because it doesn't always apply.
Right. Let me ask you about phones. You know, when we buy new phones, there are lots of conditions, and you have to check before the phone itself, allows you to operate it. Is that all part of? Does it fall under data protection?
So the text, the agreement text, it covers so many legal requirements, copyright laws, digital rights, and electronic data terms and conditions generally, and usually it has the privacy clauses in there as well that you might, as we all do, we just take it because we want the app, or we want to get whatever we are applying for, especially online, a long text, and then we just take and go. But the campaign that we have from the privacy community to developers and owners of software is that not to use this small print, the unreadable small print text, to as a privacy statement. So the accountability requirements requires that it's readable, it's user-friendly, sometimes it's explained in terms that the user can understand, for it to qualify as a proper privacy statement. This is why now you're beginning to see privacy statements on website away from the terms and conditions and the small print, because people don't usually read it. So you can't claim to have been transparent.
Then we should have a way of avoiding phones that don't meet the standards to come into the country. If you're not giving us readable texts, then we
I think it's a practice of the not just telephones, but apps and telecommunications general world of what this applies to push a lot of small print your way, because you want the phone so badly, you want to use Apple so badly that when the updates come, you just click OK and download. And so that is in their ecosystem. But the privacy community is pushing for other ways of explaining the privacy statement to individuals, such that you can say that you're fully informed.
All right. We're having a very, very important discussion with the production, that's the Data Protection Commission, and in the person of Executive Director Patricia Adusei Poku here on Good Afternoon Ghana. I'm sure you, as myself, as much as myself, we don't know a lot of these things. So you want to understand how this data protection works. Let's take a breather. When we come back, we'll deal with the second part of it, and then we come back. right, you're welcome back. We're still on Good Afternoon Ghana. I was having a chit chat with Madam Patricia. So let's just continue from there. Unsolicited messages. I don't know how the telcos work with institutions. I don't know if there is any legal agreement between them without us. You know, what's going on there? You're getting, and sometimes these natural lotteries, some of them are fraudulent.
Yes.
And that's where I probably will go in agreement with the communication ministry of, well, we want to protect your data, we want to do this, we want to do that. We don't understand that, yeah, but we have to understand at some
Yes.
point, yeah, what goes on there?
So these are unsolicited text messages. Very frustrating. When they start, you get one few and far between, once a week or twice a week. But then they become very frustrating when you start getting text messages morning, afternoon, evening, Sundays, middle of the night, asking you to buy things or to download an app or join a group when you haven't asked to be contacted at all. These are from marketers usually who wants to sell something or a service to you. These are called unsolicited text messages, meaning that you never asked for it, but you're getting it. They come from marketing companies who usually buy the database from data controllers who have more or less routinely collected the information from you from one purpose and then have decided to repurpose the data. We talked about repurposing of data earlier on. So the purpose that they specify to you has now shifted to a different use,
Right.
meaning that they have sold the data to a third party, or the data has been wrongfully accessed, or unauthorized sharing of your data to a third party group who are now using it for a completely different purpose, usually for profit maximization one way or the other. It is not fair on the individual. It can be distressing, harassing, and some people have really been frustrated to the point of even changing their telephone number for this same reason. When you get these unsolicited text messages, the telcos have the responsibility not to allow these text messages through, because you have a contract with your telco. They have issued you with a telephone number and a service to provide data and a telephone network connectivity to you. The purpose never included allowing third parties to shoot text messages to you. So for many jurisdictions, the telcos give you, the individual, the option to click stop. So if you type stop in block letters in response to an unsolicited text messages, it should stop. It should be the last
But
time
why will
you
you
get the text message.
inconvenience me so much for me to use 3 seconds to be typing stop?
So usually the reason why this facility is available is inevitably sometimes you go online to buy something, or on the internet you are downloading something, you haven't read the small text, and the small text includes, should we market to you, should we share your information to so and so company so that they can also sell to you, and you have inevitably clicked yes. Usually the legal way, that is how it tends to happen. So in the download of new apps, new software, or in going online to join a service, you need to read the text to see whether there are marketing clauses in there saying that we'll market this or that to you. If you feel that, then sometimes that's how you get these unsolicited text messages. Again, sometimes these the explainable times. This is how we tend to bring it on ourselves. But usually, especially in our African ecosystem, again, you find that data controllers who have legally collected your data, or who you have given consent to hold your data for a very legitimate purpose, tends to sell the data on illegally. It would be good for the individual who is being distressed if they can identify that this is information I gave to data controller A or data controller B. That helps the commission when it comes to complaint to address that particular data controller about these data leakages. But sometimes it's very hard to tell how these third parties got your data. They've bought it, and that buying of data in itself under Section 89 of our law is illegal. Buying and selling of personal data is illegal, but it happens. Some institutions buy secondary data. They buy from secondary sources.
Yeah.
Any proper data controller who has legitimate grounds or has consent from their customers will collect directly from you, or will collect from those you have given permission to hold your data. Those who suddenly do the cold calling or unsolicited text messages tends to buy their data illegally. When we find out who they are, if you are able to determine where the calls are coming from, we deal with it on your behalf. Many data subjects refer these to the commission and we deal with it. We've already written to the National Lottery Authority because recently people are complaining a lot about betting, unsolicited text messages about betting and gambling being sent to their phones. And so we have begun work on that. Civil servants that are complaining about unsolicited text messages, about loans and all that, we have dealt with that with the right institution. When we know where it is coming from, the commission is able to stand in the stead of the majority, because usually it's masses of people receiving this text message.
But that's
to
a
deal
lot
with
of
them.
work as an executive director, because it's a commission, not an authority. So how are you
Yes.
going to be able to, go through this difficulty and make sure, because there's a law anyway, it has to be
We are
applied.
empowered by the Act to act on behalf of individuals. It's Section 2A of our mandate is to protect the rights of individuals and their personal data. So when we start getting these complaints and we know the source, we deal with. For example, they call for betting and asking you to join a betting club or casinos. We deal with the Gaming Commission. That is our sister commission that deals with these data controllers so that they can instruct their data controllers not to do it.
So our time is up, but I can't let you go. Just give us a summary of what a person, an individual especially, who doesn't have so much power because it's not an institution, what can we do in terms of data protection? We can read about it, yes, but just in case you feel someone is infringing on your rights when it comes to privacy of data, what should you do?
So if you know exactly which institution has infringed your rights, your first point of call is to write to that institution or go there and complain. If you are not able to write, they have a duty to have a complaint system. That means an employee there can take the details of your complaint and have it addressed. If that still meets your, does not satisfy you, then you have the right to escalate the complaints to the Data Protection Commission. We always ask you to go to them first because it's simpler and easier for them to just correct things. If that doesn't work, you have every right to complain to the commission by email, in writing, by telephone call, or by coming in person to the commission. We take on the details and we look into it for you, and to the best of our efforts, address that complaint and correct the situation for the individual. Where the complaint is by volumes and masses of the public, then instead of waiting for the complaints to come in number, we take action. Like I said, we've taken action with the National Lottery Authority, with the Controller and Accountant General about civil servants' data, because we've already had numerous complaints about this. If the complaint comes from a campaign group, and we don't have enough of that in our ecosystem, sometimes we have campaign groups, civil society groups that also complain to us on behalf of communities and groups of people, and we take that on as well. We have already positioned ourselves to start prosecuting cases. The Attorney General has kindly given us a dedicated prosecutor that is going to work through the cases and complaints with us to take some institutions to court as examples for others to sit up and do the right thing with the data that they hold. Many, especially private sector institutions, are maximizing their profits based on the data that they hold. They say now your net worth is your network. So they amass a lot of information about people and use it for maximizing their profits. And so we also, when we find out, stand in the stead of the people, hold them accountable, prosecute if necessary, get them doing the right thing and respecting the rights of individuals.
All right, so you know what to do. We report to your office, right?
Yes, our website is www.dataprotection.org.gh.
Okay.
And we have telephone numbers on the website that you can call or email us at info@dataprotection.org.gh, and we will get back to you.
And that's how we can report to you?
Yes.
There isn't any other, there's no phone number?
We have social media. We're on LinkedIn, we're on Facebook, we're on Twitter, and you can get through to us in any of these areas by just Googling it.
I hope they're effective. Response time.
They do. We have staff on the chat box almost every day.
Thank you very much. Patricia Adusei Poku is the Executive Director for Data Protection Commission, coming through to helping us understand how the work actually goes. So those of you who are struggling as I'm struggling, you know what to do now. Go onto all the platforms of data protection, all social media platforms, the website, and LinkedIn if you like, and then you can access them there and render your complaint. I thank you for coming through. This has been Good Afternoon Ghana. Thank you for your time. Entertainment Review is next shortly.